Judgment in the appeal British Airways plc against Williams and others.
The judgment in this case will be delivered by Lord Nance.
This case was before the Supreme Court in September 2011, when the Supreme Court referred to the Court of Justice in Luxembourg for its answers certain questions of European law. The Court of Justice's answers have now been received, but the parties disagree about their significance. So the matter came back to us for a further hearing. The appellants are British Airways pilots, and the case concerns their holiday pay entitlement to paid annual leave under Council Directive 2079-EC and under the Domestic Civil Aviation Working Time Regulations 2004, giving this directive effect. British Airways pilots are paid a basic annual sum, plus 2 supplementary payments varying with the time spent flying, namely a flying pay supplement, FPS, of £10 an hour, and a time away from base allowance, TAFB, of £2.73 an hour. The latter is expressed to be to cover extra costs, but 18% of it is regarded by Her Majesty's Revenue as taxable. The Court of Justice ruled that holiday pay should be calculated by reference to an average of all aspects of pay linked intrinsically to the pilot's tasks, including the supplements, calculated over a reference period which is judged to be representative. The calculation should, however, exclude any components of these supplements intended exclusively to cover occasional or ancillary costs arising at the time of performance. The court said that it was for national courts to apply these criteria. The pilots argue that this is what can and should now happen. Their claims should be remitted to the Employment Tribunal for it to assess holiday pay by reference to their basic entitlement, plus the flying pay supplement, and plus 18% of the time away from base allowance. British Airways argue that whatever European law may require, the domestic regulations do not provide any machinery for the calculation of the average pay over a representative reference period, which the court has said is necessary. So, failing any guidance as to what period should be taken, the UK may be in breach of its obligations to implement the directive, but there is no basis on which British Airways was obliged to pay holiday pay by reference to anything other than basic pay, and no basis on which an employment tribunal could hold British Airways liable for failing to do so. British Airways submits secondly, and more technically, that the regulations contain no provision for adjudication by the employment tribunal on complaints relating to the quantum of holiday pay, and thirdly, they submit that the Revenue's insistence that 18% of the time away from base allowance was taxable was and is irrelevant to the question whether that allowance was paid to cover costs. The Supreme Court, in a judgment given by myself with which all members of the court agree, rejects British Airways' first 2 submissions. It is under the regulations for British Airways to assess a representative period over which average pay should be calculated for holiday pay purposes. All that is required is that the assessment should fall within reasonable parameters. Failing any such assessment by British Airways, the Employment Tribunal can and will have to make its own assessment under the regulations. As to British Airways' second point, the regulations can be read to enable the Employment Tribunal to have this power. This gives proper effect to the directive, as is the UK's duty. The case can and must, on that basis, be remitted to the Employment Tribunal for it to apply the Court of Justice's decision. As to the third point, British Airways are right that the revenue figure of 18% is irrelevant. The question whether any of the time away from base allowance should be included in the calculation of average pay must also be remitted to the Employment Tribunal for it to consider, in particular, whether there was a genuine intention in agreeing and making such payments that they should go exclusively to cover costs.